A pretrial hearing is set for today in former President Donald Trump's classified documents case. It marks the first courtroom argument in the case since Trump was indicted 5 weeks ago. Trump and an aide were charged in a 38-count indictment accusing the former president of mishandling classified documents at his Mar-a-Lago estate. He is not expected to attend this hearing, though. So for more on this, I want to bring in CBS News legal contributor Jessica Levinson. Good to see you again, Jessica. What can we expect during today's pretrial hearing?
So a pretrial hearing like this is entirely ordinary, except this is an extraordinary case. And so there are certain things we need to look to. We need to look to, for instance, what does this Judge Eileen Cannon, who was appointed by the former president and who made a ruling that was very favorable to him earlier in this case, in an earlier iteration of this case, what does she do in terms of each side's request for scheduling? So, for instance, the prosecution has said, we want to go to trial in December. We want to do this quickly. And the defense has said, let's postpone this indefinitely. So the first thing I think we need to look for is which way is she leaning when it comes to scheduling? Does it look like she's favoring the former president? Does it look like she's listening to what special prosecutor Jack Smith and his team have asked for? And related to that, does it look like she's cognizant of two other calendars? One is the election calendar. Of course, this is not just the former president. This is a current candidate for president. And is she cognizant of the other legal calendars? So the former president is also facing charges in New York related to business records and potentially in Georgia. So those are a few things we're looking for. I'm also looking to see if either side tips their hat to what type of motions they might be filing. And that could give us a bit more of a roadmap for more of the details of what the prosecution and the defense are looking to do here.
Sure. And Jessica, I want to ask you about the Classified Information Procedures Act. What is it exactly, and how will that statute govern classified evidence used in this particular case?
This is a decades-old act that was actually introduced by then Senator Joe Biden, and it's meant to balance two things. On the one hand, the due process rights of a defendant who is facing a trial like the former president is, related to national security, related to classified documents. And it's meant to allow that defendant to see the evidence against him or her and to have access to that evidence and basically to know what the prosecution's case is going to be. That's part of our due process rights in this country. On the other hand, it's meant to balance the fact that this is not any other defendant or any other case. This is a case dealing with highly sensitive information that the government does not want to be made public. So it's balancing national security concerns on the one hand and a defendant's due process concerns on the other hand. And there are pretty detailed and complicated procedures for how throughout the pretrial process, Judge Cannon is going to have to balance those two things.
So the special counsel's team has asked the judge to enter a protective order to restrict the ability of Donald Trump's defense team from sharing information with him. I imagine the bar for something like this is super high. Why would they do this, and what's the strategy?
It's very high. I mean, in part because there might be other charges coming in, of course, the election 2020 case. Special counsel Jack Smith is looking into other, potentially another case and other potential targets, and you don't want the former president to share that information and broadcast that information. In addition, as we discussed, we are talking about information that has reportedly been some of the most sensitive national security information, and you don't want a defendant to either share that or to threaten to share that. That's one of the reasons that that federal law we talked about a few moments ago was actually passed, because you didn't want something called gray mail, where a defendant would say, well, you're going to have to give me national security information and I'm going to share it unless you drop a charge against me. And that's how we often would get plea deals in cases like this. So the protective order, yes, I agree, it is a high bar. And that's one of the places where, and Marie, to your question, I think we're really going to zero in on how Judge Cannon treats the former president as potentially different from other defendants.
And Jessica, on that note, I want to circle back to something you had mentioned. Obviously, this is all happening with the backdrop of the 2024 presidential election. Trump's lawyers have suggested the trial begin after the election. Do you expect that to come up today? How likely is it that it would get postponed?
I do expect it to come up today. This is one of those, we're learning as we go, in the sense that we don't know a lot about Judge Cannon. She doesn't have a huge record for us to look at and say, oh, well, she usually grants these types of delays in complicated trials, or she's part of the so-called rocket docket in Florida, where typically her colleagues try to get cases to trial quite quickly. We don't have a lot to go on in terms of her, which is a long way of saying she has a lot of discretion here. And so I wish I could give you a definitive answer of, oh, there's absolutely no way this stretches beyond the 2024 election, or of course, we're going to hold this in a few months. This is one of those situations where it's largely judge dependent, and the judge is going to weigh the factors that are important to her. And again, we're going to see how important the electoral calendar is to her.
Jessica Levinson, thank you so much for joining us as always.
Thank you.